Good afternoon. Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. And dockets number 2021-89-E and 2021-90-E. Let's take roll. Present in the hearing room, we have Commissioner Williams, Commissioner Thomas, Commissioner Powers, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioners Irvin and Caston. Attorney Stark.
Thank you, Mr. Chairman. Mr. Chairman, other commissioners, we're here for the oral argument in the proceeding of docket numbers 2021-89-E and 2021-90-E. That matter associated with those dockets is Duke Energy Carolinas avoided cost proceeding and Duke Energy Progress's avoided cost proceeding. Mr. Chairman, the matter specifically set for oral argument is the request of Duke Energy Carolinas and Duke Energy Progress to hold the procedural deadlines in abeyance in these proceedings and to allow the interested parties to propose a procedural schedule at a future date no later than April 30th, 2021. Mr. Chairman, I believe the docket is prepared for oral argument, sir.
All right. Thank you very much. Let's take appearances to see who all we have here with us. Let's start with the applicant. Well, not the applicant, but Duke Energy.
Mr. Chairman, members of the commission, this is Rebecca Doolin. I'm corporate counsel for Duke Energy Carolinas and Duke Energy Progress.
All right. Is Office of Regulatory Staff here?
Yes, sir. Good afternoon, Mr. Chairman. Representing ORS is myself, Andrew Bateman. Thank you.
All right. Carolina Clean Energy Business Association.
Mr. Chairman and members of the commission, I'm Richard Witt from the Witt Law Firm representing Carolina's Clean Energy Business Association.
Southern Alliance for Clean Energy.
Yes, thank you, Mr. Chairman. This is Kate Mixon representing Southern Alliance for Clean Energy and South Carolina Coastal Conservation League.
Southern Environmental Law Center.
Yes, Mr. Chairman. This is Kate Mixon. SELC anticipates representing Southern Alliance for Clean Energy and the Coastal Conservation League in this proceeding. We have not yet intervened, but I did file a notice of appearance on behalf of those organizations for purposes of these oral arguments.
Okay, so you filed a notice of appearance for Southern Environmental Law Center?
For the Southern Alliance for Clean Energy and South Carolina Coastal Conservation League, the Southern Environmental Law Center anticipates representing those organizations in the later proceeding, but would not be a party ourselves. We just would represent. The intervention line has not yet occurred, so we hadn't intervened yet.
Is there anyone else? So there's no one else. So, okay. Attorney Witt, when does your client plan on intervening?
Well, for the record, Mr. Chairman, we filed a notice of appearance prior to this hearing, and we do plan to today or tomorrow, probably tomorrow, we will file a petition to intervene.
Thank you, sir. Attorney Mixon, same question for you.
Yes, Mr. Chairman, the initial notice of the procedural schedule, I don't remember when the intervention deadline was established. We plan to intervene as soon as possible. We just did not have to do so prior to this hearing.
Okay. All right. Attorney Doolin, can you tell us why we're here?
Sure, I'm happy to. Mr. Chairman and members of the commission, if it pleases you, I was going to give a brief overview of at least my understanding of of why we're here and how we got here in terms of a little bit of history of the settlement agreement that was mentioned in the company's request and steps that have been taken and activities that have been underway over the past 15 months since that settlement agreement and the commission's order. So I was going to give a brief overview of that. As always, please feel free to interrupt me at any time if you all have specific questions, but I thought that would tee up some questions from you all. I have not participated in an oral argument regarding a procedural schedule yet, so I'm trying to make sure I give you the information that you need. So please stop me at any time if this is not what you are looking for to be helpful in this regard. So I'll just take a step back. I know a number of the commissioners were a part of the 2019 avoided cost proceeding, and some of you were not, and did not have the pleasure of the pain that was associated with doing a lot of work in a really short period of time in 2019. In Act 62 sets forth a statutory deadline by which the commission had to rule on the avoided cost matters in 2019, and that date was November 15th. And as a result, the commission has a 24-month period to consider the matters again and rule on those again. The avoided cost proceeding is a biennial proceeding under Act 62. And so the commission's order in 2021 will be due, and forgive me, I'm saying order, but the way the commission has interpreted it historically, and we only have 1 year of history, but has been that the directive is issued in the November 15th time period. So under Act 62, a directive is required by November 15th, 2021. And so that certainly is a driving factor here as we work through the schedule for the 2021 proceeding. In the 2021 proceeding, the commission issued the actual comprehensive order in early January. I believe it was January 2nd. And in that order, it approved a settlement agreement that a number of the parties had entered into. And just by way of background, the settling parties were essentially the environmental and solar interveners. Mr. Witt's client, the Solar Business Alliance, as it was named at that time, and Ms. Mixon's clients as well. The ORS was not a party to that settlement agreement. They did not oppose the settlement agreement, but they were not a signatory to the settlement agreement. And that settlement was a partial settlement with regard to a very discrete issue regarding what we call the Solar Integration Services Charge. I'm happy to explain or provide more background as to what that is or what that means. But under the settlement agreement, as it was approved by the commission, there was to be an independent technical review of this solar integration charge that was to be conducted to evaluate, have a third-party independent consultant evaluate the methodology and the inputs associated with the study that creates that integration charge. And that study was conducted by a third party as well. Astrape Consulting is the entity that conducted that study. Excuse me. And so the settlement agreement contemplates or requires actually this third party independent review of the methodology and the inputs of the integration charge. So that all happened around the January time period. And at the same time, North Carolina was considering these issues as well. And in April, the companies received an order from the North Carolina Commission approving essentially the same thing, an independent technical review of this same integration charge. And the North Carolina order provided additional detail that we did not contemplate to begin with, and that is that the national labs would be an integral part of this third-party technical review. that created some complications, which I'm happy to explain, but that delayed the process of putting this review together in order to create a technical review committee that the national labs could be comfortable with, given what their mission is. They're very hesitant to engage in a disputed regulatory proceeding. And so we were able to work through that, and beginning at I guess around the December, January timeframe, speaking of January 2021, the companies began engaging with the ORS to discuss the work related to this independent technical review, and that work is significantly underway. I'm happy to describe what that is and how that work is moving along, if that's of interest to you. But that work is going to take some time, and we anticipate that it will culminate in a final report that will be issued by the Brattle Group around late June or early July. That June-July timeframe is what we're anticipating. And so that is really what leads to the company's request that we hold these deadlines in abeyance and allow the parties to work together on a procedural schedule that allows for this technical review to be conducted and submitted in the avoided cost filings that are to come in 2021, and that is what is required under the settlement agreement that's approved by the commission. And I'm sure there's some questions, and I've probably left some things out in the saga that I've just described, but that is the background of why the companies believe that a revised procedural schedule is necessary, and why they would like the opportunity to consult with the parties and work together to come up with a procedural schedule that is that could be considered by the commission that allows for this work to be completed.
Thank you, ma'am. I have a couple of questions for you, just to make sure I get my dates right. Now, when did the Public Service Commission of South Carolina issue that order? Did you say January of 2020?
That's correct.
Okay. So January of 2020 is when your client was aware of what the commission expected regarding the study, or ordered.
That's right.
Study. Okay. And you started working on that. And I know I'm skipping some parts, but just bear with me. Did I understand you correctly to say you started working on that January 2021 with ORS?
That is correct with ORS, but there was significant work that was being undertaken prior to engaging with ORS. The beginning of the work was, and Mr. Chairman, I don't have the exact dates, but was in the summertime period of 2020.
Okay. And so your order, or not your order, but you anticipate a report in July?
In the June-July time period. We've never done this before, and so we're estimating how long it will take the consultants to perform their work, but that is what we have been told.
Okay. And so your request is to hold the procedural schedule in abeyance until no later than April 30th. Do you have any idea of what that schedule would look like? I don't know what you've done. You shared with us what you've done, some of what has happened, but can you give us any idea of what that could possibly look like?
Sure.
Okay.
Sure. Sorry to interrupt, Mr. Chairman. It's hard being this far away. What we have contemplated is a mid-July filing time period. If it helps for reference, the company's direct testimony and application was filed in the 2019 case in mid-August. So we certainly recognize the need for more time than we had in 2019. And so what we have, our best case scenario to move this forward as quickly as possible is a mid-July time period. And I believe I have shared that generally with the parties, but we have not come so far as to agree to a full schedule yet. But that's what I would anticipate as a reasonable period of time when the company could file its application and direct testimony.
And when do you think approximately the hearing would start?
Based on that, a hearing would be early to mid-October.
Okay. And how long do you think the hearing would last?
I'm hopeful that we will be able to reach agreement on a number of issues with interveners in advance, because we have already done one of these cases in 2019. And based on at least my communication with Mr. Witt's client, that there is a lot of interest in narrowing the scope of issues that would need to come before the commission. Last year, Mr. Chairman, in 2019, Mr. Chairman, as you recall, I think we only took 2 days. It may have been 3. I know we certainly had a very good reason to work through that hearing as quickly as we could, given your upcoming leave. I would not anticipate that the hearing would take any longer than that in 2021.
Okay. Now, you are aware that we are a new commission since 2019. I think the last time, so you're anticipating 3 days
I am.
based on what you saw in 2019.
Yes, Mr. Chairman, and I would say also that in 2019, we had a number of issues to work through that we had never worked through before. The parties had never worked through before. I certainly understand and am very cognizant of the fact that this is a new commission, and very much and hearings have been taking a fair amount of time recently. However, I do think, and I would be curious if the parties are in agreement with this, but I do think that given the resolution we have reached on a number of issues related to contracting documents and things like that were brand new. We had never established a notice of commitment form in South Carolina before. We now have a basis for that. We had never established a PPA for what we consider to be large renewable developers under PURPA. That was brand new. There are a lot of issues that were brand new that the parties had not yet had an opportunity to litigate before. And my personal opinion is that given that we have a basis for those decisions and for decisions related to the avoided cost rates as well, that it certainly has the opportunity to be a more prompt hearing in 2021. But as hopefully you all can understand, I cannot predict all of this. But those are my thoughts on that, Mr. Chairman.
Okay. So I'm just looking at this from a hypothetical perspective. Let's say we started this hearing on the 18th of October and we finished on the 20th. The commission's order would be due the 16th, I believe it is. 1, 2, 3. 1, 2. So that's about 3 weeks. Do you think that's enough time for the commission to fully consider all the facts and evidence presented and render a decision?
Mr. Chairman, I think that's fully within your discretion. I really could not say, and I don't want to guess as to the amount of time it takes this commission to do its job. If this is going to present an unworkable problem, then I think what we should really consider is how we could amend the settlement agreement or something in that regard to provide more flexibility on when the results of that study may be presented to the commission if this is going to create an unworkable procedural schedule for the commission. The companies are certainly respectful and cognizant of the amount of time and work that it takes for the commission to evaluate all of the evidence in a complicated proceeding like this. And by no means would want to put the commission in a position of feeling like it does not have sufficient time to properly consider the evidence.
Okay. Those are all my questions for now. Vice Chair Belzer?
Thank you, Mr. Chairman. Good afternoon, Ms. Doolin.
Good afternoon.
Ms. Doolin, why would it take until April 30th to come up with a proposed procedural schedule for us to consider?
I proposed that amount of time just to hopefully give the parties, given the number of parties that participated in this proceeding in 2019, an opportunity to consult with their respective clients. And I was concerned about the amount of time that it may take to do that. And certainly that can be revised if the commission would like the parties to put together a proposal earlier than that. I frankly was just concerned about the number of opinions to take into consideration in trying to work through a solution.
Okay, I appreciate that. I mean, we're already scheduling matters into September. I know I've seen a couple of things that have been put out that far, and that's why we were holding time in August, because as the chairman indicated, we're pretty much a brand new commission, and we seem to be asking a lot of questions, and hearings are taking a little bit longer than what has been anticipated. And this, as you've acknowledged, is an extremely complex case that we are anticipating. I presume that the parties are going to want a transcript following the hearing and to be able to prepare proposed orders. And y'all it sounds like right now there might be a month between a hearing and the due date. At least we agree on the due date of, actually I think it's November 16th, because the act became effective on May 16th. So at least we're in agreement that what our timeline is. So knowing that that's a hard stop, we need to work back and figure out how we can accomplish what's needed here. So I don't know if any of the other parties in your discussions, has everybody kind of been in agreement that that's a hard stop date?
Yes, Madam Vice Chair.
Okay. It's quite a quandary we've got here. You mentioned that there were some complication with the national labs, and as I read your letter, the national labs were providing experts to kind of be the to judge the or review the study. Is that what was going on there?
Yes, Madam Vice Chair, they are participating as what we have called technical leads. So they are conducting the study and the evaluation. The challenges that we faced to begin with was trying to narrow the scope of their work sufficiently so that they would be comfortable participating in this work because it is part of a contested regulatory proceeding, and they were really hesitant to do that given that their mission is related to energy research and development, and they don't see it as part of their mission to be engaged in a contested regulatory proceeding.
Okay.
And as a result, to resolve this, we hired the Brattle Group as what we call the principal of the review committee. So Brattle will organize everything and will actually write the report that will be provided to the companies and then to the commission. And that's how we were able to resolve the issues with the national labs, because the North Carolina order requires the engagement of the national labs. And for the most part, Mr. Wood's clients and Ms. Mixon's clients are all working on this in the North Carolina former proceeding as well. And so that's where we ran into the hiccup with the national labs. And of course, we understood where they were coming from, and we all worked together to try to resolve those issues.
So y'all are hoping to file the application in July and have the hearing in October. We've already opened the docket. If parties go ahead and intervene, can they go ahead and file discovery on other matters so that they can get a leg up on discovery, and they're not trying to do all discovery from the time that between July and the hearing and whenever the hearing might be, if we go with this schedule?
I think that's something we should definitely look at.
I tell you, I have, this is just me, one commissioner, but I really am trying to guard the time we have after a hearing and the time when we need to be continuing our review of testimony and transcripts even before the proposed order gets here, so that we can feel like we're making the best decision. And I think this is something that everybody needs to be aware of going forward, because I am fighting tooth and nail to protect the time that I need to be able to do the best job that I can. And that's really the time between the hearing and when a decision has to be rendered. And going forward, I mean, look around. This is a brand new commission. And just because things were done one way in the past, that doesn't mean that that's going to carry over to the future. I'm not saying that just to you, Ms. Doolin. Everybody needs to be aware of this if they aren't already. And maybe I'm just slow. Maybe I just need more time. But I do try to protect that time that I need to digest and understand and formulate opinions and discuss with different staff members or commissioners. So let me just be aware of that I do guard that time very jealously. So, all right, you've given me something to think about. That's all the questions I have at the moment, Mr. Chairman.
Chairman Williams.
Commissioner Caston?
Ms. Dillon, I think this is the first time you've met or talked. I'm not sure.
We may have talked in an oral argument previously, but I think you were in a different location, so you look brand new to me now. It's nice to see you, though.
Unfortunately, I look the same all the time. I hate that too. I'm one of those new commissioners that Vice Chair Belson was talking about, and I certainly understand what you're saying, that this is all new. This is all new to Duke and everyone else. It was also all new to the commission. It's very new to me. So if there's such a thing as a double new, I guess I'm that. Kind of going back to that January
2020 question, I think Chairman Williams asked, that, I'm trying to understand the process or the time from that point until, I think you said around summer, is when you started really getting into it and determining maybe who your consultants were, who's doing what, how you're doing it. Is there any particular reason it took 6 months to determine that? Would you not have started doing that like January 15th or 16th? Or?
Sure, I'm happy to explain. So this issue of the solar integration charge was also being considered in a very identical proceeding before the North Carolina Utilities Commission. And the parties are very similar in the South Carolina proceeding and in the North Carolina proceeding. And in formulating the settlement agreement, the parties understood that this technical review that's required in the South Carolina settlement agreement would be the same technical review that would be conducted pursuant to the North Carolina proceeding. Because at that point in time, when the settlement agreement was being contemplated, we also expected to have the same requirement for the independent technical review in North Carolina. And so the problem we ran into is that in January, we had an order from the South Carolina Commission, but we did not have a full order from the North Carolina Commission yet. I completely understand that that is not the South Carolina Commission's problem. It also is a practical reality of trying to do business in 2 states and streamline the work of the technical review into one review, one set of costs, as opposed to doing duplicate work. And so that delay, we received the North Carolina order April 15th. And so that period from January through mid-April was waiting on the North Carolina order. And then subsequent to that, now certainly should we have started the work on April 16th as soon as we got the North Carolina order? Maybe so. But the reality of it is that there was a significant time period there waiting as a result of what I've described.
Well, I guess you kind of hit on what I was thinking as you were talking to Chairman Williams and Vice Chair Belcher. And I get it. I understand that, okay, it's 2 different commissions and you would prefer to, kind of do this one time since you're going to be acquiring or needing the same information. I get that. You're trying to do it as efficiently and as effectively as possible for your customers, for Duke. I get that. But having said that, though, I would think, okay, in January, you kind of knew what at least South Carolina was wanting, and not sure what North Carolina was, but you probably had a sense. And perhaps, as you say, if you could have been doing as much of the preliminary identifying, doing whatever necessary up until that April 15th time, and that's out of the way. And then you could start April 16th and do it. But water under the bridge is always easy to discuss. I'll agree and admit that. But my concern personally is, I'm still trying to, learn how to do this and do it well, because I want to do it well. And part of that does involve time. And I've observed in these things, there is a lot of information you guys send. And I actually like to go through it, especially the studies and that kind of stuff. Just can't do that at one sitting. I mean, 3 weeks sounds maybe great to some. I don't know. But my general sense or opinion is that I'd rather have more time than less time, just like I suspect you guys would. So I've said all that just to maybe complain about the past. Certainly, I believe from this path forward, we should be able to work all this out where this shouldn't be a problem in the future, should it?
Sorry, I'm trying to be careful not to interrupt you and not to make Ms. Weed's job even more difficult than it is. But and the same when Vice Chair Belzer was speaking, I completely understand. I think just based on the interactions I've had with the three commissioners right now, it may be wise for the parties to think about more creative solutions to this, whether it is some sort of amendment to a settlement agreement to provide that the companies don't need to file this report with the 2021 avoided cost proceeding, or whether it is some kind of bifurcation of this docket where certain issues can be addressed early and other issues will be addressed in the fall. It may be more cumbersome from a procedural standpoint, but it also could protect the time that is so valuable to you as the commission. And so I would really like to think about that some more and confer with the parties on potential options, because I really hear what you're saying and what Vice Chair Belzer has said. And and as I've described to Chairman Williams, we certainly do not want to interfere with the commission's time needed to evaluate the evidence and the issues. So I really think that the parties, particularly my client, needs to think about this a little bit more and see if there are some creative solutions that we can come up with.
I appreciate that because you know, my desire and my natural tendency is to try to find a way to make things work, to try to help. It really is. But I don't really know how much it really takes. How much leeway do I really have? If that makes sense. So I don't want anyone to think that, and I'm only speaking for me, that I don't have a desire to try to accommodate and help all any way possible. I just don't know what the limits are. I know my limits, and there are many. I require time just because I guess I'm just a slow thinker, I suppose. But I appreciate you thinking that way and suggesting that.
Sure.
With that said, I have nothing more.
Thank you,
Mr. Chairman.
Vice Chair Belzer.
Ms. Doolin and other parties, I don't want to leave a false impression here, because I understand that the applicant needs time to present or prepare and present a completed application and prepare and present good testimony. I understand that the parties need time to conduct their discovery and make their cases. And I don't want to short any of the parties that appear before the commission, because the better cases y'all can present, it helps us. But I just realize that we need sufficient time too, and I don't want that to be overlooked in the grand scheme of things. Don't get me wrong, I appreciate all the work, I've been on some of it, that goes into preparing a case, and I understand somewhat the difficulties and the challenges of preparing a good case. So I'm not trying to shortchange y'all, because the better cases you're able to present, that helps us. So I just want to make that clear, that I'm not unsympathetic to the challenges that y'all face either. But I'm also trying to balance what we can do here. So I appreciate your suggestions, Ms. Doolin, and the other parties may have some too. I did note in your letter that you indicated that the report is needed the independent technical review, so that before the company can file the application, is it something that is needed to file the application, or can it be a placeholder in there until it comes in? And that's a question that you may have to discuss with other parties, because I don't know how that may impact their view of the application, and if it's integral to the other costs that are in there, it may not be something that can easily be separated out. But I just kind of am curious about that. I understand the need to get the report before a hearing is scheduled, and with the parties having enough time to digest it. But I don't know. I don't have an answer right now. It's just kind of all theoretical.
Well, Vice Chair Belzer, if I may, the reason that I stated that in the letter is because the settlement agreement, best laid plans, the settlement agreement says that the company shall include the results of the review in its initial filing in the next avoided cost proceeding. So those words that the results of the review shall be included in the company's initial filing is what led me to draft the letter the way it was drafted. If that just helps put some pieces together for you.
It does, and I had pulled the order and had read through portions of the settlement agreement. I think I read over that. So thank you for that clarification. I appreciate it.
Sure, thank you.
So, Attorney Doolin, appreciate the way you've given us a background and also offered some paths forward. Really appreciate that. Before we go to the other parties, or I shouldn't say parties, the other interested parties in this oral argument, is there anything else that you would like to say? Ms. Doolin?
I'm sorry, Mr. or Chairman Williams, I was thinking. I certainly hear the concerns of the commissioners. Vice Chair Belzer, I didn't respond directly to the concerns that you raised about the importance of protecting your time, and that this is a new commission, and that certainly is not lost. It is at the forefront of our minds, and I think the companies have felt a bit stuck, and this conversation is very helpful to, again, thinking through potential options that we have not considered previously. And so I just want to mention that we certainly hear you loud and clear. I will be passing this on to my clients, and I think it's important for us to understand and more fully, and it's very important to us. So that's Chairman Williams. Thank you.
Attorney Witt?
Mr. Chairman.
Oh, I'm sorry. Commissioner Thomas.
Thank you, Chairman. I just had a comment or a thought, really, not a question. Just hearing all that's involved in this, things around here are not getting any less complicated, or we're not getting less things on our schedule, and a lot of things end up having to happen at the same time with other entities, and it just it's just getting more and more complicated, which just makes me think that it's time now to start thinking about the 2023 schedule. And in my opinion, that involves the same people we're talking about right now. It involves Duke's internal schedule. It involves the scheduling with other parties, the independent technical review, how this may or may not interface with what's going on at the North Carolina Public Service Commission, and certainly with the South Carolina Public Service Commission. So I'm just gonna toss that out there so that, maybe in 2 years from now, things move a little bit more smoothly. That would be my hope. Um, and, yes, I agree with the vice chair that we have to have our own time to work through all of this. And, appreciate you listening to my comments. Thank you. That's all I have.
Thank you, Commissioner Thomas. All right. Attorney Witt.
Mr. Chairman and members of the commission, Richard Witt here for the Carolinas Clean Energy Business Association. I'll start out with my original thought that, as outlined by Duke's counsel, my client CECIBA also believes it's necessary to establish an updated procedural schedule, especially with regard to the completion of an independent technical review of the company's solar integration charge. However, I have, of course, heard and listened to you, Chairman Williams, and Vice Chair Belser, and Commissioner Caston, Commissioner Thomas. In light of your colloquies with Ms. Doolin, we certainly will go back to the drawing board on coming up with an earlier date to come back to the commission before April the 30th. And I also want to state that not only are we going to be working on coming back with a good procedural schedule that we're in agreement on, we certainly will be working with Ms. Doolin's two clients in order to reach agreement on some issues that we're discussing right now. And the advanced time that we'll have in the next several weeks to discuss those issues with Duke's counsel hopefully will lead to us settling some issues which will lighten the load when we actually have to come back before the commission. Additionally, CECIBA wants to point out that it's going to work with Duke and other parties concerning some issues in the integrated resource planning documents of Duke 224 and 225. And we need to work on those discussions because we believe that some of those issues will have implications for the matters that will be addressed in this proceeding. And also, as required by the statute, there's a number of issues in the voided cost proceeding that are predicated on information and conclusions within a utility's integrated resource plan. So we believe that those implications may also support the need to reconcile the procedural schedule between those respective proceedings. We do need that and support the request for an abeyance, but as stated, we now believe that we need to work and come back much sooner than April 30th. And we appreciate the opportunity to appear in front of the commission today.
All right. Any questions for Mr. Witt from the commissioners? Don't see any. Attorney Mixon?
Yes, thank you, Mr. Chairman, Commissioners. It's good to see all of you again today. And I know you've also seen a lot of me as well this year. And so, we are certainly very aware of and understanding about the number of proceedings and the scheduling constraints that the commission may have. I would just, echo Mr. Witt's comments a moment ago. We joined the letter from CECIBA just to note that in addition to the technical review regarding Duke solar integration charge, that there are also several issues related to the ongoing Duke IRP proceedings that will also be relevant in these avoided cost proceedings. And that, to the extent that certain issues could be narrowed in scope or resolved through the solar integration charge process or the ongoing IRP, could also help with narrowing some of the scope of issues that would have to be addressed at the avoided cost hearing. And would also, again, just echo the comments from Ms. Doolin and Mr. Witt about there being potentially creative solutions that we think would work for both the parties and the commission regarding a procedural schedule moving forward. Thank you.
Any questions for Attorney Mixon? Office of Regulatory Staff?
Thank you, Mr. Chairman, members of the commission. Andrew Bateman, representing the Office of Regulatory Staff. I have a few really brief comments. First, I want to thank the commission for allowing us to discuss with the commission this matter. I wanted to briefly explain ORS's part in the Solar Integration Services Charge Technical Review Committee. ORS is participating as regulatory observers, which I understand means we are obviously observing what takes place, and we're providing recommendations and input as necessary. We reviewed the letter that Ms. Doolin filed previously, and as stated in there, we do not oppose Duke's request. I'll also reiterate much of what Ms. Doolin and Ms. Mixon and Mr. Witt stated. We're certainly happy to work with the other parties on coming up with a procedural schedule that's amenable to folks prior to April 30th. And one final thing that I'd mention, Mr. Chairman, this has to do with an order coming out of docket number 2019-182-E. We think respectfully that if an order could come out, it could be very helpful in this proceeding. It could be helpful to inform aspects of the framework which are necessary to the avoided cost analysis and analyses. And I'd just like to mention that for the commission. Thank you very much, Mr. Chairman.
All right. Any questions for Attorney Bateman? Anything else before we adjourn? All right. We're adjourned. Thank you.
Thank you.